I will note that for the record, I did receive a sentencing memorandum last week that included a lot of other attachments. I don't think we're not going to go over it, but I issued something last week, which is in the file, just talking about so everybody knew, and I didn't have to deal with arguments about whether or not I could. But this was a no contest plea, and there were several assertions of facts that, to the extent that they disagreed or were inconsistent with the exhibits that the court used for taking a no contest plea, the court does not find it appropriate to consider them. All right, so let's take a look here at the PSI.
The defense did receive the court's order on Friday. Thank you for the court's guidance, and we'll go forward. I assume the court did receive all the letters as well.
I did, and I read
that.
I read every single one and made blue ink marks in pretty much every one, so I would remember.
Court's guidance, Ron. Thank you.
Mr. Denham, now for victim impact statement.
Thank you. First, in no particular order, first people would call Miss Gracie running.
I was standing by the fire, surrounded by friends, enjoying the night, when out of nowhere, a gunshot rang out. It took me a moment to process what had just happened. When I looked up, I saw Kevin holding a gun. My mind immediately flooded with questions. Who was this man? Why was he here so late? And why did he have a gun? Around me, I could hear my friends asking the same thing as we were all confused. Kevin and his brother stayed at Logan's house as people tried to figure out what was going on. We all wanted to move on with our night, but the tension was in the air and it felt like it was growing. Then the conversation grew louder. I do not like confrontation, so I decided to move further away, hoping to avoid whatever was unfolding. Then a fight broke out. I heard yelling, followed by another gunshot. That was the moment I realized things were spiraling out of control. Fear took over me, and my first instinct was to get away. I turned and ran towards the woods, trying to distance myself from what was happening. Even as I ran, the fight continued. I could still hear the shouting, struggle, and the desperate sounds from someone yelling, "Please stop hurting Seth." But Kevin didn't stop. Shaking, I grabbed my phone and started calling for help. First, I called my dad, voicemail. Then my brother, voicemail. And then my uncle, voicemail. Each call had rang through to the voicemail, and the beating continued throughout each one. Every time the call went unanswered, my panic grew. I was terrified that no one would come in time, and finally I called my mom. When she answered, I blurted out, "Dad needs to come help. Kevin has a gun. He's shooting it. He's beating Seth, and he won't stop. No one can get him off of Seth." Someone else in the woods with me was also calling for help. We just needed anyone at this point to come. But by the time I repeated myself, the fight had finally ended, and my friends had came to find me. When I stepped inside the house, I saw Seth. His head was split open, covering his face in blood and clothes. His clothes were covered in blood. He was trying to wipe it away, but nothing could undo what had just happened. We all stood there, shaken, waiting for help to arrive. Since that night, I cannot stop replaying in my head what I saw and heard. The gunshots, the person screaming, and fear of not knowing what would happen next. My most recurring thought, if Seth, a grown man, couldn't defend himself against Kevin, what would have happened to me or anyone else? Kevin's actions that night proved how quickly he can escalate a situation into something violent and dangerous. Someone capable of that kind of aggression, even after people begged him to stop, is not someone I feel safe being around.
Thank you, Mr. Denham.
Thank you. Next, people would respectfully call Mr. Deacon Doty. I wrote down some notes about how this affected my life and all about it. And so at night, I got to sit there and think about my friend's safety, living right next door from him, and how if he can make it through the night, I don't know, just for safety, and then for Seth's safety after everything that happened. I don't want anything coming back on him and trying to get vengeance on it. And another one, I have to live with the sound of hearing a gun hit my best friend's head about 3-4 times, and I don't know if you ever heard it before. It's not a very pleasant sound. It's gonna stick with you forever. And I can't go to my buddy's house, and without worrying what's gonna happen at the night, if we're gonna make it home safe the next day, all that stuff. And I got just no remorse for anything. He's not taking action for it and trying to deny it, even though we all witnessed what happened. It doesn't set right. About all I got for you.
Thank you. And Mr. Denham, I think you said 3.
Yes, Your Honor. Next, the people called Mr. Seth Wilson.
I'd like to start by thanking everyone for being here today. It means a lot for so many people to take this event so serious. As far as what I have to say, I believe the actions of Mr. Scott last November should not go unnoticed or be swept under the rug. The emotional trauma endured by not just myself, but my friends that were there is one thing. You also have to account for the fact that this man is dangerous. I believe that he had an intent for something to go on. There's no other reason for someone to be discharging a firearm drunk, coming onto private property without an invite or even a notice. Personally, in my life, I've seen people go away for a lot less than this. The gruesome and brutal actions that happened that evening will stick with me and my friends for a lifetime. A slap on the wrist is not going to take that away. I do fear for the safety of myself especially, just based on what had happened that evening, without ever even meeting Mr. Scott prior. I had 9 staples in my head the next day when I woke up, along with a gut-wrenching feeling knowing what my friends had gone through and witnessed. It's sickening for someone to approach a group of young adults in such a horrific manner. To be there on the ground, getting hit repeatedly, and just asking myself if I was even going to make it out. That was the scary part for me, knowing that my friends' lives are in danger from the moment he approached. And for every one of them to not be able to speak in front of this crowd at sentencing was very shocking to hear. They are victims just as much as I am. That is all I have to really say. I know that this should not go unpunished. I believe that there was an intent to hurt or potentially kill that evening. I hope with all the evidence and statements you can understand where I'm coming from. Thank you, everyone.
Elocution.
Thank you, Your Honor. Just briefly, I'll keep my part short, Your Honor. I've submitted our sentence memo along with all the letters. The court will note that Mr. Scott has an enormous amount of support in this community. He's a business owner, employs people. What happened that night was out of character and horrible, Your Honor. Mr. Scott is here to take responsibility for his action. I will note his family and friends are here. He does have a lot of support, Your Honor. While on bond, bond was uneventful. There were no violations on bond, Your Honor. And I will note, in his prior, more than 10 years ago when he was younger, he did have some misdemeanor events. But the important thing to note there, I think, is that he was always compliant on probation and bond. I didn't note any violation, which tells me that he takes what this court tells him to do seriously, and he has done that on bond, Your Honor. So with that, I would ask that the court take due consideration of the letters and support. And while this is a no contest plea, Mr. Scott does want to speak and apologize for his actions, but I'll keep it short, Your Honor. Thank you.
All right, thank you. I'll have Mr. Scott at the end after I hear from the people. Mr. Denham.
Thank you, Your Honor. We would respectfully ask that the court order the $2,288 in restitution to compensate the victim, Mr.
Oh, hold on. I forgot to write that down. It's 2,800.
No, Your Honor, $2,288.
Thank you.
So we would respectfully ask that that be included in the order. Your Honor, as we always do, that being the people, we meet with the victims. In this case, we met with Mr. Wilson several times, asking what he would like to have happen in terms of a potential resolution. He indicated in this case that he wanted accountability. He absolutely did, but he indicated in his words that he did not want to ruin the defendant's life. He indicated that he did not want prison. That's what the message that was given to me. Those words, that input was incorporated into the plea offer. I would note that the defendant has pled to 3 separate felonies. We believe that the recommendation, both in terms of the PSI report, as well as Mr. Wilson's recommendation in the PSI report, he's asking for 12 months. The recommendation on the PSI report is a minimum of 10 months. We believe that that's in line with the agreement, and we would respectfully request the court file the agreement with the parties.
All right, thank you. One moment, please. In this case, I don't think a prison recommendation was made. That's all. Thank you. No idea how I remember. All right. Mr. Scott, you have the right to make a statement. Now, before I turn it over to you, I understand that Mr. Mankiewicz says you wish to make a statement. I will note that this was a no contest plea, which means whether you do or do not make a statement, they won't impact me. I don't think it would be, I generally don't think it's appropriate, especially when it's a no contest plea. because there's a reason why the law allows you to enter one. Is there anything you wish to say, sir?
Honestly, words fail to express how sorry I am for the role I played in that night, and I'll live with this the rest of my life.
I went through and I read every one of the statements submitted, and having obviously been, as I said earlier, in another file, most of my career has been at the defense table. Whenever I read, and I'm not going to ask everybody to chime in, I always wonder if everybody who is writing a letter has read the entirety of the police report that the court has considered, at least in taking of the no contest plea. We live in a small community, both over here in Missaukee County and over in Wexford County. And as we all do, we all tend to know people and overlap knowing people. And I have had people try to send me messages, instant messages and letters, either or even approach and talk to me. A lot of people that I know about this case. I want you to know, especially those who sent me the messages, I don't read them. Once I realize it's going to be about a particular case, I delete it. So I had a couple people, and if any of those people sent me something and they wonder if I read it, the answer is no. Don't send me a instant message on some kind of social media. Don't send me an email. Once I get the inkling that it's going to be about a particular case, it's gone. And then if my friends try to talk to me about it, stop, don't, appreciate it. Thanks a lot. So I just want to cover that. The reason why is because it's ex parte. And here, when I look at these, the sentencing memorandum and the letters, they're all here and open, and Mr. Denhoughton can respond to them. And even so, Mr. Scott can too, through his counsel. I understand there's going to be some defensiveness. There are two different sides to every case, and there's two different sides to this one. This would not, despite the openings to the repetitive theory, that's the theme that's in these letters. This was not a compassionate man that day. And there are a couple of people who wrote letters. I can tell you, two of them who were involved in the case, I disregarded your statements. One of them was the person who was his spouse and lied when the police came and docked her. No, we don't have any of those guns. Even the defendant said, no weapons here, because he hid it outside on a log. Yeah, no. Your letter meant nothing. It didn't help me very much. You lied your tail end off to the police officers. I have no idea what made you think that that was going to be a good approach. When the police officers came to you, you lied. And in this particular case, the defendant lied not once, but lied multiple times when the police officers talked to him about it. There is no weapon. But you just pistol whipped him, was one of the questions from one of the deputies. Nope, no weapon here, he said. Or denied even owning a firearm. Both he and his brother own the same firearm called, which of course is kind of ironic here, the Judge. He denied it at least 3 or 4 times. I may have lost count. No. He didn't even get charged with possessing a firearm while under the influence. He's got a significant benefit here. No felony firearm charge with the 2-year mandatory prison term. That was dismissed, which is fine. I'm just talking about the benefit that the defendant gets. By the way, one of the best things here about this case is this defendant cannot possess a firearm for several years, which means any firearm in the house is within his custody and or control. That's what the word possession means. Every firearm in that house has got to go. I don't care if it belongs to somebody else. It's within his area of control. And as we talk about in the instructions for the jury instructions, possession doesn't mean ownership. It means area of control. He should not have access to any weapon as long as the law will allow him, which will take a few years before he can ever possess one. In fact, when one of the statements came from the brother, I discounted his statement because, and here it says on CFJ 284, page 5, the brother denied that he and the defendant crossed the street or left the scene at any point after the altercation. Well, the other evidence is they left. So everybody on that side of the street, because these people live across the street, was lying. So the defendant decides that he wants to walk across the street because he's upset. By the way, there's a party going on for kids at his house. And so he doesn't like maybe the noise or whatever's going on across the street out in the country. Something possessed he and the brother, especially while intoxicated, for him to grab a firearm and go across the street, shoot it to scare the heck out of everybody, and then pistol whip. Not once, but he pistol whipped another person. The defendant, while drinking, is a danger to himself and others. He should never drink alcohol again. That is for certain. And I wrote down here, I sometimes come up with little themes, and of course here I focus on the fact that it's a 45 Colt revolver called the Judge. And apparently Mr. Scott thought that day he was the judge. And again, anyone who would try to approach me and talk to me outside, I would ask you, did you read the police report? Because if you did, this police report describes an incident that is woefully different than the person everyone described. What makes a person walk over with a loaded gun while drunk and start shooting it to scare people and then pistol whip another person? Now, I get to use the pistol whip because he did not go to trial, which is fine, which means he waived any self-defense argument or defense of others. One person said they heard the bullet whiz by their head. Another person said that there were actually 2 shots. And then here's another one. While she's not charged, I don't know why she didn't get charged, which is okay. I'm not challenging. Interference. She went across the street and tried to interfere and tell the other people, hey, this everything's fine, everything's taken care of. Try to downplay the severity of the incident. You can't downplay a severity of an incident. You weren't there, and you're not the one with a lacerated skull with blood flowing down your head. I had no idea what you were thinking. So, everyone, I understand the defense. This is probably, if the defense isn't drinking, he's probably perfectly fine. And by the way, the defendant owns a business. He's got multiple people and family members and employees that rely on. Great. But none of those employees sat there with a gash in their head with blood flowing over the head with a drunk guy shooting a gun at a piece of property that's not his because he didn't like whatever noise was going on by a bunch of 20-year-olds, who, by the way, probably need to grow up a little bit, but that's just because I'm an old guy. All right. No. Danger to self and others. And I'm really sorry. You got a lot of obligations riding on you, a lot of people counting on you. That is not, the only thing that's going to sway is I'm not going to give you a prison term. I want to send you to prison. And by the way, there's a killable agreement between both sides. Killable agreement means that if I don't go along with it, he can withdraw his plea. You have no idea how tempted I am to give you a prison term. You've got issues here where you've got alcohol that you've dealt with in the past. Please note that there are a couple findings, a couple cases here in the past. And when I try to make this statement, if they were dismissed, like entry 3 of 7, I of course disregard those. I do note that you completed probation successfully in the past. And I'm going to tell you that's about the one thing you have going in your favor. You do have a 10-year gap. That's the second thing that's going on in your favor. A 10-year gap means that some of those priors don't get scored. The court places the defendant upon a period of probation, the recommended period of probation. By the way, the probation officers who filled this out, you'll note that on here it says their names were withdrawn from it. Lansing doesn't want me to send you to prison. because they're probably overcrowded. I do. The probation officer does. He cut a deal with the defense, the prosecutor, and the victim seems to think jail is fine and prison isn't required. So that's what I'm being told. So, all right. The court places the defendant upon a period of probation for 36 months. I adopt the terms or conditions that are listed on CFJ 145, pages 3 and 4. I find that they're well suited for rehabilitative purposes. The court highlights that the defendant is not to possess or use alcoholic beverages or other intoxicants or illegal or controlled substances, and he will be subject to testing. He'll be subject to treatment if directed by the probation officer. Now, while he's on probation, he will have a curfew for which there will be no exceptions, at least according to the court, between 11 p.m. and 6 a.m. Of course, with this felony conviction, your ability to possess firearms, will be limited by law, but even while you're on probation, you may not possess any firearms or use any object of a weapon. And I let you know that if there is one firearm in that house, it's gotta go. Don't anyone come to me and say, well, it belongs to Melanie or it belongs to somebody else. It's in his house. It's gone. The defendant will. This is going to be compliant with the Killebrew agreement, although it's going to be different than that which was recommended by the Department of Corrections. Court sentences the defendant to a period of jail for 365 days, and that has 2 days of credit. That will apply to each one of 3 offenses. I note that here, the 2 of the counts are intermediate sanction cells of 2 to 17. I find that pursuant to this law, the guidelines are inadequate to discuss the circumstances here of this particular situation. And yes, I know, folks, I am talking a little bit tough because I want to break through the sugarcoating. I understand that Mr. Scott, probably a good guy, great guy in most situations, but when consuming alcohol and possession of a firearm, you all better watch out. And it's by the grace of the prosecutor and Mr. Wilson, who apparently supports, as I'm being told.
Can I say something about that? Because they told me that there was probably no chance that he was going to get prison time. I didn't tell them I didn't want him to go to prison. That is not what I said.
Okay.
Like I said in my statement, a lot of people, I've seen people go away for a lot less than that.
Okay. I appreciate that, Mr. Wilson. Now
I hope it's clear.
all right. Thank you, Mr. Wilson. You'll note that why I repeated that statement, that what I've been told, I repeated it at least 3 times. And I looked at you each time because I wanted to see what your head shape was.
We strike the attorney fee.
Oh, we strike the attorney fee. Thank you. I'm so sorry, Mr. Nicholas. All right. Well, Mr. Denholm, I thought you said the Mr. Wilson agreed with the recommendation that he didn't want prison.
I stand by my statement. That is what Mr. Wilson indicated to me, Your Honor. We went over guidelines, those were his statements specifically. So I stand by my statement, Chair.
And I understand, Mr. Denholm, sometimes in those conversations, understandings between a lawyer and what a non-lawyer hears and says, I got it. So I'm not pointing any negative finger at you. But now I'm wondering, what do I do? All right. Well, I have announced the sentence. I'm going to keep the sentence as given. I will note that when there are violations of probation, because it's 365 days, any probation violation could result in a prison sentence, which means for 3 years, he'll have to be perfect. He can't drive, he can't get a driving license suspended, anything else like that. I can tell you though, I wanted to give you prison. This was just a terrible, terrible situation. But I'll tell you, it will not give you work release, which means you're going to stay in there for 365 days minus your good conduct time. You had all of that. And I want to, if any of those people want to come up and say, hey, Judge, my job is more important than a person who got pistol whipped and the gunshots. Yeah, the answer is I'm really sorry. Blame your employer. All right. Because that is within the Killebrew agreement, Thank you. We're adjourned.